I'm Rob Trasinski. This is Symposium, where we talk about the ideas at the basis of a free society. Today, we're talking about the leaked Dobbs opinion on that will expected to overturn Roe v. Wade, but we're also talking about one of the issues behind that, which is the doctrine of unenumerated rights and how that's protected in the Constitution. My guests today are David French, who is from the Dispatch, a lawyer and constitutional lawyer as well. David, thanks for coming on.
Thanks for having me.
And I've also got Ilya Shapiro from, well, Ilya, where are you from?
Falls Church, Virginia, currently. I'm sort of in between jobs. I don't know if it's called fun employment, but it's something. I'm formerly of the Georgetown University Law Center, formerly the executive director of their Center for the Constitution. Before that, formerly vice president and director of the Cato Institute's Center for Constitutional Studies. And I think tune into Tucker Carlson tonight. You might know where my next affiliation might be.
You find out where your money's coming from Tucker.
Because I announce all of my professional developments and most of my personal ones in national media of various kinds. So maybe I'll have a third Wall Street Journal column in a week or something.
Oh gosh.
All right, so I want to get to the main topic here that we're going to talk about.
Most importantly, oh my gosh, I'm falling down on the job. Most importantly, my most important title is author of Supreme Disorder: Judicial Nominations and the Politics of America's Highest Court. You can see the hardcover behind me. The paperback is coming out July 5th, and it's updated with the latest 2 years developments.
Good work. I think we'd have to pull your writer's card if you didn't plug your book. All right, so to get to the main topic of today, I mean, I think we can have a whole conversation about what happened at Georgetown and what's happening right now at the Washington Post. That would be a whole interesting conversation on its own. But I wanted to go to, we had this leaked opinion in Dobbs versus Jackson Women's Health Organization, an abortion case. Everybody just calls it Dobbs. So we have this leaked opinion in Dobbs, which seems to be a legitimate leak, seems to be a real draft of an opinion that is expected sometime in the next month to be released in its final version and to overturn Roe v. Wade. Now, what I want to talk about is not so much the abortion issue, although I'm sure we're going to get into that, but what seems to be the central constitutional law issue here, which is the doctrine of unenumerated rights. Now, the Ninth Amendment says the enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, that creates a sort of paradox here, which is this is a very explicit guarantee of rights that are not explicitly named at all. And kind of the whole point of guaranteeing them in the Ninth Amendment is the fact that they're not explicitly named. So from a constitutional law perspective, what do you do with that? How do you guarantee rights that are not specifically named in the Constitution? So I want to get sort of Ilya's perspective on this first. I'm going to go to David on that question next.
Right. Well, there's two answers to this question. One is if you're writing on a blank slate, and the first time after the enactment of the 14th Amendment, the Supreme Court is presented, or any federal court is presented with this question of a claim that a right is being infringed, and where do you go? How do you understand what is meant by the 14th Amendment's protections for due process of law, equal protection of the laws, or the privileges or immunities of citizenship? And as a good originalist, you look at the original public meaning of those clauses with reference to the equivalent of the Federalist Papers for the original Constitution, the amended Constitution, the debates in Congress over the 14th Amendment in 1868, statements by such figures as Representative John Bingham and Senator Jacob Howard, who in turn referred to lots of things like Corfield versus Coryell, an 1823 case written by Justice Bushrod Washington, George Washington's nephew, riding circuit, not a Supreme Court opinion, but he's been sitting in Pennsylvania Circuit Court interpreting a different provision of the Constitution, the Privileges and Immunities Clause of Article 4, and goes into things like natural rights, civic rights, the right to earn a living, the right to armed self-defense, the right to your property, the right to trial by jury. So it's not purely natural rights that exist in the state of nature, but certain things that make up the privileges or immunities of citizenship. Similarly, due process of laws means that not that a well-functioning kangaroo court would satisfy that. There is some substance to that process. and equal protection of the laws means everyone's treated equally, and all these. So you look at documents and dictionaries and how people, the meaning of the words on the page when they were enacted. So that's option one. It took a little while to explain, and you could go, if I were an academic, I would take 3 hours just to get there. Option two is what Justice Alito is trying to do, and saying, given the full gamut of Supreme Court jurisprudence on this question, where do we go from here? And the established jurisprudence says that you look to substantive due process, the way that, because privileges or immunities were short-circuited very soon after the 14th Amendment was enacted, eventually when substantive rights claims began to be protected against state violation, the Supreme Court did it piecemeal via a doctrine called incorporation, incorporating rights against the states. And for unenumerated rights, or those that are not explicitly specified, the governing test now is from a case called Glucksberg from 30 years ago that talks about whether certain rights are deeply rooted in the nation's history and traditions. And that's what Alito is doing for the most part in that draft opinion. Having received some commentary on that draft opinion, kind of a wiki style, unusual, unprecedented development, evolution of the opinion, eventually we might have, the final one might have more originalist takes. But those are the two ways that a judge could go about understanding this question.
Right. So it strikes me that the problem for originalism that's posed by the Ninth Amendment, though, is the fact that you can't just go to what was the original meaning of these things, because it's inviting you to bring in something outside of what's already listed, of what's already enumerated in the documents. Right. So saying, well, we've mentioned some rights, but there are others. And it by its very nature, it tends to evoke the unwritten, or the not already explored or already established. So I don't know, David, if I can get you to comment on what your view is on this, on how you would use the Ninth Amendment and unenumerated rights.
Yeah, I would push back on that a little bit, because the original understanding would be that the Bill of Rights, that there were rights that existed when the Bill of Rights that was written that were not articulated in the Bill of Rights. So essentially what you have in the Ninth Amendment is like a savings clause that is trying to square the circle between the anti-federalists and the federalists, where you're talking about the federalists were saying, we don't really need this Bill of Rights, because what you have the liberty, you have all of the liberty except that which is sort of clawed back to you by the enumerated powers of the Constitution. So the Constitution's a limited document. It has limited enumerated powers. Where its power doesn't reach you, it doesn't have purchase over you. So why do you need to list rights? And there's dangers in listing rights, because if you list your rights, you're going to miss some. What are we going to do? Like, list all of the rights that human beings have? And the anti-federalists are sort of like, hey, belt and suspenders, guys. I mean, don't assume that this much larger federal government that we're creating is going to stay neatly in its little box. Let's list some of the key rights that exist, that human beings possess. And so you have the Bill of Rights, which is listing some of these key fundamental human rights that we should all possess. And then kind of has this savings clause that says, don't think this is all of them, don't think, but it's not saying, don't think that we just listed all of them for the late 19th century, but there might be more in the future. They're referring to an existing sort of set of understood rights. And so, this is what Ilya is talking about. He was talking about some basic property rights. I mean, Akil Amar at a National Constitution Center event that I was at says, hey, even if you take the Second Amendment to say that the Second Amendment's about a real well-regulated militia and not about an individual right to bear arms, the Ninth Amendment would encompass that sort of individual right to bear arms as a fundamental aspect of a right to self-defense. And that there are rights that did exist that were not enumerated, that were understood at the time. It isn't sort of a catch-all provision that says kind of whatever right you want to have, you get to have through the Ninth Amendment, much less the 14th Amendment as well, with his Glucksberg analysis. And the interesting thing about the Alito opinion, though, this is fascinating to me, is the Alito opinion is saying essentially, hey, let's look at what is, deeply rooted in American history and tradition. Let's look at what people what was the state of the law when the 14th Amendment was passed, when you're talking about abortion. And you feel like he's kind of setting you up to also eviscerate some of the rights that have been granted under 14th Amendment jurisprudence, unenumerated rights like same-sex marriage, a right to private sexual intimacy, and other rights, contraception, etc. It's almost like he's saying, wait a minute, these things were not, if abortion wasn't rooted, these things weren't rooted either. But then he goes on and he says, but abortion's different. Abortion's different. And so don't think that what I'm writing here about abortion is going to cast into, or should not undermine in any way some of these other rights, same-sex marriage, sexual intimacy, etc. Even though you can't really find a deeply rooted in history and tradition kind of argument for them either. Which has led to thousands and thousands and thousands of words being written about whether the draft Alito opinion will undermine, gay marriage, or undermine Lawrence v. Texas and other cases like that.
We can go into that if you want, Rob. But I wanted to mention one other thing. At the outset of your question, you said that things that aren't explicitly written in the Constitution, well, that's not part of constitutional analysis, and that's not correct. That's not how originalists or even textualists go about their work. There are plenty of terms in the Constitution that aren't readily apparent what exactly that means, how it would apply in a given situation. The reasonable in the Fourth Amendment, or cruel and unusual punishment in the Eighth. What does due process in and of itself mean in the 14th Amendment? Interstate commerce, the Commerce Clause, the power to regulate interstate commerce. So it's not that to be a good originalist, you cannot look outside the four corners of the text. No, but it's not simply a thing. Well, the text is ambiguous, therefore judges get to do whatever they want, or what they use their judgment to invoke justice. No, that's not originalism. Originalism looks at extrinsic evidence. The Federalist Papers, the debates over the ratification of any given amendment, dictionaries, to ascertain, to try to get at what the original public meaning of a provision might be. And there could still be disputes. The Heller case, the Second Amendment case from 2008, both Scalia for the majority and Stevens for dissent were doing, legal history, trying to understand the meaning of all the words of, so you could have debates among originalists, but it's not correct to say that it's not good originalism if you have to go outside the explicit words on the page.
Yeah, and as David was talking about, I know there's also, you refer to basically the rights or the political principles that were understood at the time, the rights that people were understood to have at the time, outside of, even if they're not mentioned.
Well, I would push back on that as well, because it's not necessarily understanding that matters. It's the meaning of the words. People can be, they can mean lots of things, but if the words are more expansive or less expansive, then that's what governs. At that point, the words on the page do govern, which is why, for example, even though nobody in 1868 was contemplating same-sex marriage, it's a very colorable claim under the Equal Protection Clause. How Obergefell, the same-sex marriage case, was decided. Justice Kennedy's opinion muddies that up by mostly relying on due process or creating some equal dignity clause or something. It's unclear what the actual rule of decision in that case is. But just because nobody contemplated something or didn't understand it in a given way, doesn't mean that the words on the page don't mean what the words on the page might mean, whether it's tomorrow or 150 years from now.
Okay, so that leads to what I wanted to have as the next issue to go into, which is the things that people didn't contemplate. Because David mentioned there's this little extraordinary little passage where in this leaked opinion where Alito says, well, this ruling here, on Roe v. Wade, it doesn't affect all these other things. And he gives this whole list. And there's a whole set of this, it's something I hadn't appreciated as much before, that Roe was part of this whole constellation of sort of late 20th century, and a couple of them are very early 21st century decisions having to do with contraception, having to do with interracial marriage, having to do with medical decisions, your right to make personal medical decisions. And you can see how, sex, marriage, procreation, medical decisions, Roe is sort of at the center of this constellation, this intersection of the constellation of all these decisions. And what I find fascinating about that is these were issues that, when an issue comes up to the Supreme Court and the Supreme Court has to make a decision, it's usually because this was not something that was ever contemplated or discussed before. It's because it's new. And you had these, for various reasons, things that had not been contested in the courts before. And so you had things like, some that were technological, technology that didn't exist or was not widespread before. Some because things that, like, for example, what's, you just mentioned it, the one from Texas about anti-sodomy laws, where, basically laws that made homosexuality illegal. That was one where no one, I think, had contested it because you had a small and despised minority that didn't think it could win at the courts. So it was never contested because nobody thought they'd win. So you can have cases, I think, where somebody clearly and fairly unambiguously has a right. But if your standard is what's well established in tradition, that could lead you to deny that right because, oh, well, it's, you can't show that people recognize this or widely granted this right in 1789.
Well, I think that it's absolutely the case that if you're going to look back at the understood state of human liberty in 1789, that is not, even if there are rights that would have existed in 1789 for individuals that are not outlined in the Bill of Rights, the suite of rights that human beings, we think, should enjoy was not protected in 1789. I think we can agree on that. I would say that the suite of rights that we believe people should enjoy was not even fully protected by the Civil War amendments, although Civil War amendments by their text sweep pretty broadly. When you're talking about due process of law, privileges or immunities, when you're talking about equal protection, these are things that sweep pretty broadly. And the language sweeps even broader, as Ilya was talking about, than some of the practice of the time. But for example, there's a reason why it was deemed necessary to have a constitutional amendment for women's suffrage, even after the 14th Amendment, although I'd argue that a pretty colorable equal protection claim could be made for granting women the right to vote. And so the issue is much less, in my mind, should you have a right to X? Okay. That's a question that is not necessarily the answer to that of should you have a right to X does not necessarily answered by going back to the Constitution itself. So rights are created in a number of different ways. For example, the right the right we enjoy and take for granted to be free of racial discrimination in employment and private employment is a right granted by statute, not by the Constitution. And so for some of these liberties, the question is, so for example, should I have a right to contraception? Yeah, absolutely. Does the 14th Amendment grant me the right to contraception? Does it really? But should I have a right to contraception? 100% yes. And so that's where a lot of the tension gets, is that sometimes people say, well, I absolutely should have a right of contraception, or the federal government or a state government should not really be regulating what happens in the bedroom between consenting adults. Where does that right come from? What is the source of legal force? And it's not the case that we can say that, hey, if there's something that I believe should be a right, and I really want it to be a right, that I can find that right in the 14th Amendment. And I think that's where a lot of the disagreement and the difference arises, is that if you feel like I can't even imagine living in a free country without this right, well, it's got to be constitutional. And I think that that's where some of the differences arise.
Well, in the leaked Dobbs draft, I noticed that he mentions there's a lot of emphasis on this deeply rooted in historical tradition as one of the tests for an unenumerated right. But there's also another clause thrown in there. It says, or implicit in the concept of ordered liberty. And I think that maybe, and that's sort of dropped then after that to focus on, let's look at the history. But that implicit in the concept of ordered liberty is a much broader thing, and maybe gets to more of what you're talking about, David, which is there are certain things where you say, the Constitution guarantees liberty, and if you want to, spell out the full implications of what liberty means, it's going to have to mean the government can't tell you what to do in the bedroom. If you start saying, oh, well, the government can tell you what to do in the bedroom, it starts to, do violence to the concept of liberty itself. So that's where we're in sort of tricky territory. I don't know if Ilya, if you have a comment on that.
Yeah, well, this is the problem with doing non-originalist analysis. Alito is in Earth 2, or in the kind of the second best world, where he's not looking from a blank slate. He's building on pre-existing jurisprudence and frameworks with this deeply rooted implicit and ordered liberty. That's the Glucksberg language. Again, that's a Supreme Court opinion from 30 years ago. And I'm not sure, I don't fully agree with how David characterized the nature of rights. I fully agree that it's not something, the definition of a right is not something that someone feels is very, very important, or a lot of people feel is very important, healthcare or whatever it is. But it's not people who exercise rights that bear the burden of justifying them. It's government restrictions of any kind of liberty that bears a burden of justification. And what that burden is a subject of debate. There's lawyers have come up with, judges have come up with the rational basis test and strict scrutiny. That's kind of artificial, but regardless, the point is, David was talking about, we can't enumerate all of our rights. I mean, did you know that, that we have a fundamental basic constitutional right to wear a green hat while walking on the right side of the street? I mean, that is a strongly protected right. Where does it say that? Nowhere. But, the government, if it wants to restrict me from doing so, better have a pretty good reason. There's construction on that side of the street. Okay, that's a good reason. Or, the green hat restriction, I don't know what a reason for that would be. Similarly, that's really what Alito is getting at, a second best solution for answering of why there's a difference between contraception or human intimacy versus abortion, in that in one circumstance, it's consenting adults, it's conceptions of privacy, which we've had these conceptions from time immemorial. In another circumstance, at a certain point, there's another life and being, there's another human being with rights. And that's what distinguishes abortion from all these other cases. And then the cases of where there's two, interracial marriage or same-sex marriage, at that point, you also get protection issues, not just fundamental rights issues or consenting adults issues, but the state has to justify differing treatments and things like that when there is no other human being is directly involved or harmed.
Yeah, so talking about this idea of the enumerated powers, I think we talk so much about unenumerated rights because we don't talk enough about enumerated powers, right? If you had more of the attitude, the government has a certain very limited number of things it's allowed to do, and it doesn't go beyond that, then you wouldn't have to talk as much about the unenumerated rights. But an interesting formulation on this, one that I found very clarifying, and I think gets to the heart of why we have so many debates over this. An old friend of mine came up with the formulation that he said that the way to understand the Ninth Amendment is, what it really means is insert political philosophy here. And that when you say there are other rights we might have, right? You're inviting somebody to say, well, what are rights? What is their source? How do we know we have them? You're inviting them to consider issues of political philosophy. And the problem I think we have is that if, for the founders, when they were writing that, they would have known exactly what the political philosophy was that they wanted you to refer to. The natural rights philosophy of Locke and Sidney and all those guys. That was widely established. It was sort of universally adopted. They considered it uncontroversial, at least in an American context. And I think part of the problem we have now is that is not as widely accepted and uncontroversial. That original sort of political philosophy on which America was based was kind of dropped in the late 19th, early 20th century. And then we're trying to piece together, how do we deal with this concept of unenumerated rights without the philosophical foundation to say what rights are and how do we know which ones we have?
I mean, I get that argument. I what I feel like ends up happening, and this is an argument I've had going all the way back to law school. that in essence, what you're talking about is the ambiguities in the Constitution render it not so much a code of laws, but a statement of principles. And that the state and the principles are sort of directional, that sort of towards more liberty, more that the Constitution is kind of pointing you in a direction. It is not a document to be construed in the way that you would necessarily construe a statute. You know, a statute is going to be more precisely drawn. It's going to be something that is going to be much more susceptible to interpretation by the text itself. Whereas the Constitution has some ambiguity specifically in it, like the 9th Amendment, like the 10th Amendment. And I get it. I get the argument, and I understand that. And I know that originalism is not like a scientific method where you can just sort of sit there, and if you just get enough originalists in a room, you're going to really understand what this actually completely, totally, objectively means. But there's a difference between believing one fiction, which is that this Constitution is subject to completely precise, scientifically accurate understanding on all points based on original public meaning of this document. There's going to be given those joints. To one that is essentially saying, well, what this document is doing is kind of pointing towards an evolving understanding of liberty more broadly.
I think that goes to what I was saying, though, about how the original natural rights philosophy was kind of dropped. And I think what we got in the sort of among the quote unquote liberal justices, the left of center justices, was more of a sense that rights come from social consensus. And they come from, what's the phrase? The evolving standards of decency in a progressing society. I can't remember the exact phrase, but it's that notorious phrase about these evolving standards of decency. So it's more like your rights come from social consensus rather than a natural rights philosophy.
Right. I mean, but it would usually meant their consensus, because often what the Supreme Court was doing was getting well ahead of the social consensus. Right now, well,
it's everybody that Felix Frankfurter had a dinner party with had a consensus on this issue. Yeah.
If social consensus contradicts the text, it doesn't matter what social consensus is. I mean, you know what, part of the reason for the Bill of Rights is a counter-majoritarian, counter-consensus, right? So why you have a right that you have to articulate is if there was a social consensus against reasonable searches and seizures, and that this was something that against unreasonable searches and seizures, you don't need that firewall there, but there's a constant police consensus kind of pushing it towards unreasonable searches and seizures.
Yeah, rights are the ultimate counter-majoritarian check. You don't need the First Amendment to protect popular, uncontroversial speech.
Right, exactly. So I've always had a critique of the social consensus argument, because the reality is what's happening is the Supreme Court in many ways has been extremely counter-majoritarian in social consensus. Well, which consensus, which emerging, evolving consensus are we talking about? Then we're talking about the Supreme Court acting as Ruth Bader Ginsburg said in her Madison lecture, and all the way back in 1992, legislatively. And Ginsburg said, yeah, the court should act legislatively, and the court should act like a legislature. But her critique of Roe back at that time, 19 years after it was decided, was they just went too fast. Yeah, you should a court legislate, but it should do so interstitially, very sort of gradually. And Roe was, quote, and this was her word, breathtaking. But she had a legislative view of the court that she articulated in that lecture.
So I want to talk about, though, if the concern I have with the Dobbs draft that's been leaked is that it seems to have a more restrictive view of how you look at unenumerated rights. And it takes this idea of it has to be deeply rooted in tradition to basically mean, the problem I see with it is, if you have this attitude and the way that it approaches deeply rooted in tradition, basically, if it was so deeply rooted in tradition that you would recognize it under the approach Alito is taking, it would have already been enumerated. It would have already been spelled out at the time. So, it doesn't sort of allow for these things that are rights that are not so much invented, but discovered later on in response to new questions and new technology or new situations. And the thing that I find interesting about there is how negative this ruling is about Lochner, because that seems to show a sort of anti-unenumerated rights approach, because Lochner was one that was based on recognizing the right to contract as an existing right, and if there was something that were actually rooted in tradition, in long established tradition, the right to contract and the right to to engage in free commerce would definitely qualify, even more so than abortion. So I'm concerned that there's, let's talk about a little bit Lochner, about, there's the long tradition of hating on Lochner, and I'm a pro Lochner guy. So Lochner was, I think it's interesting, sort of a sign of the times. You talk about the subjective interpretation, that for a long time, unenumerated rights were in bad favor because the left didn't want the unenumerated right to engage in commerce to get in the way of all of the big regulations that they wanted to impose.
Oh, okay. There's a lot to unpack there. I don't, there's plenty to critique, and I do, about the Glucksberg deeply rooted test. I don't think a valid one is that, if something were so deeply rooted, it would have been enumerated, because as David said, they simply could not enumerate everything. And it's not that we didn't have any rights in that 2-year period before the bill, after the Constitution was ratified, before we had a Bill of Rights. So it's not that it has to be so deeply rooted that it was enumerated or fits into one of the enumerated rights or something like that. So I don't think that's valid. But you do touch on the kind of contradictions and problems with the deeply rooted test. First of all, by part of that Glucksberg test, the first step is to articulate what the right is exactly is at the right level of precision. What's the right level of precision? I don't know. The Raich versus Gonzalez case about prohibiting medical marijuana, even when the patient in California was complying with state law, was just growing and consuming it in her own backyard, in her own home. How does Congress get to regulate that under the Commerce Clause? And it's a whole convoluted reasoning. But how do you articulate that right? Is it the right to consume marijuana? Is it the right to consume a substance, to grow a substance in your own home? I mean, all of these different things are depending on how you define the right that's at issue, answers the question of whether it's protected or not under the deeply rooted test. So a better way of, and that's what gets you into the Lochner problem. I mean, Lochner, by any conception of what deeply rooted is, the freedom of contract, other economic liberties, which had gotten disparaged since the advent of this incorporation test, applying the Bill of Rights to the states, it gets attacked by both the left and the right. The left because it doesn't like economic liberty, the right because it doesn't like substantive due process and thinks it's a stand-in for abortion. And neither of them are correct in my view. I'm pro Lochner as well. Going back to those debates over the 14th Amendment or Corfield versus Coriell, economic liberties, freedom of contract, freedom to sell your own labor, all of these sorts of things are certainly as essential as anything else that you could name.
I think this goes back to the difficulty that, I think in the attempt to knock down Lochner in order to basically give a free field to the New Deal legislation, you got rid of this concept. Essentially, the concept of unenumerated rights sort of was disused for a while. And then you had the left trying to bring it back in a way with Roe and some of these other decisions to bring it back to within the field of personal liberties. And I think it creates this opening for this idea that, oh, well, see, this is all just subjective. It's all a matter of,
well, this is the problem of not being originalist. Not Roe, but Roe's precursor, Griswold, and even Griswold's precursor, Eisenstadt v. Baird, contraceptive cases. That's where the whole penumbras and emanations, where is the right to privacy in this context, sexual privacy? Well, it's not the 9th Amendment. It's not that was Arthur Goldberg, Justice Goldberg's concurrence. But the majority talked about how it's, you have all of these other protections, the 4th, the 5th, the 7th, all these things that sort of get at, they have emanations, and those, it was like a physics problem. The emanations overlap, and in the shadows, the penumbras, that's where you find this right to privacy that protects these other things. It's very convoluted, very atextual, and yes, does grant license for judges to find whatever rights they want. And as Justice Brennan would go on to say, it's the rule of 5. Whatever you get 5 votes for, that's your law. That, of course, is not the rule of law. That's the rule of man.
Yeah, and I think that comes from the fact that instead of doing a straightforward Ninth Amendment argument, you have to sort of try to bring back the unenumerated rights, but do it somehow by reading them into something else and going through this prestidigitation to do that. But I think one of the things to recognize here is, as opposed to sort of a straightforward story of good guys versus bad guys, we are actually in an inherently difficult situation, which is there's always a difference between what's right and what's the law, right? The law is what has been written down and stated as the law of the land. And it's not always going to be perfectly consistent with what is the right thing to do, or what is it that we think the government ought to be able to do and ought to not be able to do. And we're always going to be dealing with, because the law can never be perfect, we're always going to be dealing with those gaps.
Well, and here's where I have some sympathy for my progressive friends. The 14th Amendment is not super clearly written in a lot of ways. So it does articulate some pretty broad principles that you then dive into. You might dive into sort of the ratifying debates and what people were understanding in their ratifying debates, or sort of what was the state of state law at the time of ratification. But that's all secondary to the text itself, as Ilya was saying. And the text itself is pretty broad. It's pretty broad. The better argument, I agree with Ilya from the beginning on same-sex marriage, was the equal protection argument. It's interesting to me, and there's sort of this academic argument about, well, wait a minute, is it due process or privileges or immunities that's really the hook for, incorporation of rights to the states? And how broad is equal protection? What does it exactly mean? And sometimes it's pretty broad, and sometimes it's weirdly narrow. So in the college admissions context, somehow equal protection means definitely not equal protection when it comes to, race-based admissions. It's so, part of the reality is that we're dealing with, especially with the 14th Amendment, where the fact of the matter is that the unenumerated rights jurisprudence is much more rooted in the 14th Amendment. The actual jurisprudence is rooted in the 14th Amendment. And
let's back up a little bit. That for those who are not as familiar with the history on this, is that the unenumerated rights applied to what the federal government can do, and you could say implicitly it also applied to the states, because the government is a guarantor of those rights. The federal government is guaranteeing those rights. But of course, that was the whole issue of the Civil War. So after the Civil War, they said, let's put this in an amendment. Let's make this explicit, that the federal government has the power to enforce your rights not just against encroachment by the federal government itself, but against encroachment by the states. And that's where you get this doctrine of incorporation. And that's where you get all this stuff comes out. You're right, that all this stuff comes out of the 14th Amendment, because that's what specifically authorizes that enforcement.
Well, and even beyond, yes, and even beyond the doctrine of incorporation itself, sort of the substantive due process right is rooted in the 14th Amendment, which is not incorporating any of the elements of the Bill of Rights. It's, locating rights in the due process clause itself of the 14th Amendment. And so, yeah, this is a broad amendment. It is not precisely targeting exactly what the privilege or immunities are, what equal protection means. Taken as a whole, they're part of this suite of Civil War amendments that are designed to sweep away the badges and incidents of slavery. So there's sort of a lot there to argue about, to be honest. That's what I talk about when I say originalism isn't science as much as maybe many originals would want it to be. Especially when it comes to the 14th Amendment, it seems to me that there's a lot there to fight over, because the text still matters.
Right.
The text still matters. The ratification debate doesn't trump the text, and the text is pretty broad.
And it reflects the basic dilemma, which is that we have to start with the law, but we're starting with a law written 150 years ago, which we're applying to situations coming up in contexts that are very different, has very broad language, applied to a context that's very different from what anyone was thinking about or considering at the time it was written. And yet they create, it's like the whole issue of the Declaration of Independence saying all men are created equal at a time when that wasn't implemented. But then you have that broad language that is there for people to say, all right, let's figure out how to implement that. And now obviously the Declaration of Independence isn't the law of the land. It's a statement of principles. But the same thing with the 14th Amendment. It has very broad language, which then you have to figure out 150 years later in often very different contexts. What does this mean? What does it imply? How do we take this broad language and put it into a case which by its nature, nobody could have considered at the time?
I just forgot my thought in response to that. I'm sorry.
It was profound, Ilya.
It was. Now it's lost to the times.
Here.
It's so deeply rooted, but
the French have a saying, "The wit of the staircase," which is the thing you remember. I should have said that as you're walking out.
The wit. I like that.
Yeah, as you're walking out of the party, the great brilliant saying that you should have said.
There's one, while Ilya's recovering his thought, let me just say one thing about this. What complicates matters is that you can't subscribe to what I call 18th century infallibility theory, which would also be a 19th century infallibility theory, which is essentially that anything that the generation did that ratified these amendments tells us what these amendments really mean. By that standard, the Alien and Sedition Acts would indicate that the First Amendment is a radically limited free speech doctrine, as opposed to the radically expansive free speech doctrine that the actual text itself would suggest, that sometimes ratifying generations act in manners that are utterly inconsistent with the law that they just ratified, which is a very human thing, by the way. People pass laws and then don't want to live under the strictures of the laws that they pass. And so it's a mistake to sort of say, well, whatever was happening in 1869 or 1872 or 1875, much less 1801, 1804, 1805. Well, that explains what the Constitution is more than the text itself.
So wait, we came into this.
Remarkably, that's exactly what my thought was. I now remember what I had to what I was thinking. That's that it's not the case that anytime there's a new or unforeseen circumstance that we're in uncharted waters and the Constitution doesn't provide for it or needs an amendment to deal with it. So, for example, the congressional power to regulate interstate commerce. Well, just because the framers didn't contemplate railroads, let alone jet planes, doesn't mean or modern shipping methods or what have you, doesn't mean that it's very easy to apply that power to interstate shipping of by truck, by plane, by container ship, all of those different things. Just because the Fourth Amendment protects against unreasonable searches and seizures, but the police at the time did not have cars, doesn't mean that we don't know what to do about police doing their jobs with vehicles or something like that. So yes, there can be true difficult situations and conundrums because it's hard to analogize about property rights over a tweet or who knows what. But certainly, just because technology wasn't even within the realm of conception when something was written down doesn't mean that we need a constitutional amendment to deal with this circumstance.
So the substance of this, though, is on the issue of abortion. So I don't know about Ilya, but I may be the most pro-choice person here. I know I'm definitely way more pro-choice than David. So what would you prefer as your argument on this issue for your position? What do you think the constitutional issue? How do you think that, independent of Roe, independent of Dobbs, how do you think the constitutional issue on abortion should be judged?
Ilya, you want to take that first?
Yeah, sure. Well, Roe itself was clearly wrong. Building on this penumbra's emanations, constructing out of whole cloth a trimester rubric of when states can regulate, when they can't. Justice Blackmun's famous research at the Mayo Clinic, as if that has something to do with anything, armchair medicine or what have you. And that's why it was criticized by John Hart Ely at the time, leading liberal Yale law professor, Ruth Bader Ginsburg herself, and all the rest of it. I mean, I think that lawyers, judges cannot answer the fundamental question at issue in abortion cases, which is when do rights begin? It's not even when life begins. It's when do rights attach, whether that's birth, conception, ensoulment, quickening, first trimester, second trimester. Peter Singer, right? Birth plus a 30-day money-back guarantee. All of these things can be debated politically, theologically, scientifically, but not lawyerly. And so the Constitution is silent. Or as Justice Kavanaugh put it during our argument in Dobbs, why shouldn't the Supreme Court take a neutral position, stay out of it, which means sending it back to the states?
Yeah, I would echo what Ilya says too. It's just difficult for me to look at the text of the Constitution, much less the history, much less any remotely debatable concept of originalism, and say, yeah, this document protects a right to abortion. Roe, and you can really see this actually in the case law when they're trying to do it. If you look at Roe, as Ilya said, was a bad decision. It was recognized as a bad decision by a lot of pro-choice activists at the time. This is just bad reasoning. If you go to Casey, which attempts to sort of reestablish a right to an abortion, kind of sort of overturns Roe without overturning the right to an abortion, but kind of tries to reestablish a right to abortion. In what's called the sweet mystery of life passage of from the opinion, it really, when you look at it, you're struck time and time again that what you're reading is legislation. What you're not reading is legal interpretation in any real classic sense. That what you're reading is what is quite obviously judicial policy making. What you're reading is exactly the kind of reasoning that applies to a lawmaking process. I disagree with some of my friends on the right who say that the 14th Amendment actually bans abortion. I disagree with that. I don't think there's really any that is a supportable position by the text, history, tradition, etc. But the idea, and I think it really becomes much more clear if you read Roe and if you read Casey, not from a standpoint of, this is what I want. Are they making an argument for what I want? But from a standpoint that says they're trying to figure out what the Constitution means. If you read it from that perspective, you really begin to see the flaws in Roe and Casey, because they're totally written from a perspective of, this is what we want the policy to be.
I look at that passage where he talks about this constellation of other decisions having to do with bodily autonomy and medical decisions and, the right to have a private sex life that's not controlled by the government. And I see Roe sort of being, or at least the right to abortion being, sort of at the nexus of all those things. So I would go with the formulation of what's implicit in the concept of liberty, and find a protection of it in the unenumerated rights there, as what's implicit in the concept of liberty is the government cannot be basically dictating your personal medical decisions about a pregnancy. But like I said, this is my non-constitutional lawyer's opinion. What I'm more concerned about is talking about that constellation of other things, and Alito sort of really promising us he's not going to touch any of that other stuff, which doesn't reassure me in the least. The last question I would do, sort of lightning round response from you guys, is, are we possibly facing a point at which there's going to be less protection of unenumerated rights, or maybe we're still in an era of less protection of unenumerated rights? And what does that perhaps imply?
No is the short answer. I think there's a continuing ongoing debate about the scope of unenumerated rights, how they're justified. We might see a concurring opinion. We're likely to see a concurring opinion to Alito's from Thomas and Gorsuch, maybe joined by someone else about the Privileges or Immunities Clause. Whether that analysis yields different results, I've written 3 law review articles on the Privileges or Immunities Clause, so I have my answers, but what the Supreme Court says obviously matters a whole lot more. One of them is Keeping Pandora's Box Sealed. That's from 2010, co-authored with Josh Blackman, while the court was considering McDonald versus Chicago about incorporating the Second Amendment. And Justice Thomas had an important concurrence. He only joined Alito's majority in the judgment, which was based on substantive due process. Maybe he'll do the same thing here. Who knows? But there's the debate continues over the scope of rights. But I don't think it's a matter of we'll have less rights if Roe goes. This is about abortion, and I agree with Alito. Certainly, the biggest thing I agree with him on is that abortion is different from other things, just like death is different, as is said in death penalty cases, from other kinds of punishments.
One quick response to, will we have more rights, fewer rights? Well, there's a strong argument that overturning Roe grants more, because there is another human being involved here who had zero rights and was barred from being granted any rights by any state. And so if you want to talk about opening up to actually, connecting with the vision of 1776, and we're endowed by our Creator with certain unalienable rights, among them life is the very first one. And so I would say, if you're overturning Roe, it's actually an expansion of the most important liberty, the right to life. And so I don't look at Roe as a liberty restricting decision. I see it as a decision that at least gives state governments a chance to grant the fundamental liberty to another human being, and that is the liberty, that right to life. So, and also, if the opinion means what it says, and a lot of people, they don't believe anything justices that they disagree with say, if the opinion means what it says, this court is essentially, at the same time that it's overturning Roe, is reaffirming Obergefell and Lawrence v. Texas and all of these other cases by saying that overturning Roe does not in any way undermine them. And so it's sort of setting them in a different category. So you might find some people who would try to use Dobbs to try to challenge Obergefell, for example, but Dobbs itself does not give them purchase to challenge Obergefell. Dobbs itself says, don't use this to challenge Obergefell.
And you would have at least 5 justices agreeing to that. So you would need to find another 5 justices to disagree with that and actually challenge Obergefell. Highly unrealistic. Highly unrealistic.
So yeah. I don't see a threat to unenumerated rights. I do see an expansion of liberty as a result of the Roe decision, and that expansion of liberty will accrue in many, many, many states to the unborn child.
I am concerned that the idea of the principles involved, that it is a more restrictive view of unenumerated rights. But of course, I'm also one of the guys out there still pining for the lost Lochner era. Anyway, I know Ilya has to go, so I want to thank you both for coming in and talking about this and helping us puzzle through this question or problem of how you interpret the Constitution to protect the unenumerated rights.
Well, thanks so much for having us. I appreciate it.
Thank you.
Yeah, thanks, Ilya. I'm Rob Trasinski. This is Symposium. My guests today have been David French and Ilya Shapiro. You can find more discussion at symposium.substack.com. Please like this video if you're watching it on YouTube. Helps us get more viewers. And subscribe to the podcast. And thank you for joining the conversation.